Hello. Today is December 11th, 2020. This is my third edition of Justice and Fairness in Policing. My name is Norman A. Carter, Jr. I am a retired Philadelphia police corporal who served 25 years in that department. In addition, I am an author of my autobiography, The Long Blue Walk, My Journey as a Philly Cop. When honest conversations take place between police officers and the members of their communities, we often find that many problems do not lie solely with police officers. They also may lie in governmental and judicial stagnation and indifference. Today, I would like to talk about unreasonable searches. The Fourth Amendment. The right of people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause supported by oath or information, and particularly describing the place to be searched and the persons or things to be seized. Philadelphia's police department has had a long history of police officers drafting and executing unscrupulous and sometimes illegal search warrants. I wrote about one such incident in my book. It happened in my own narcotics squad. I handled it. Read my book for details. The several incidents that I am personally aware of had African American victims. This brings me to this year's incident in Louisville, Kentucky, involving the murder of Miss Breonna Taylor by unscrupulous police officers whom, with the complicity of a magistrate and a district attorney, secured a no-knock search warrant. It was to be served after midnight at the apartment residence of Miss Taylor. There are some circumstances about this particular warrant that are glaringly problematic for anyone experienced in obtaining and verifying the validity of a search warrant. Remember the Fourth Amendment. What were the exigent circumstances that required asking for a no-knock warrant? Investigations have shown that after the warrant was signed by a magistrate, the officers executing the warrant were told by superiors to forego the no-knock provision. They were instructed to handle this warrant in a normal manner that required vigorous knocking at the door, loudly announcing who they were and why they were there, and after a reasonable time entered the property by force to prevent the destruction of evidence or escape by the target of the investigation. Subsequent to the murder of Breonna Taylor, the initial investigation showed that none of the 12 residents in that apartment building heard the police officers announce they were executing a search warrant. Much later, one resident stated that he heard police officers announce their presence. This is problem number one. When announcing a search warrant, there's normally enough noise made to be heard a city block away. In the confines of an apartment building shortly after midnight, nearly everyone in the building should have heard or been awakened by the noise. Obviously, this did not occur. My opinion, and this is only my opinion, is that the officers executing the warrant ignored the directive to forego the no-knock provision. They neither knocked loudly nor made a clear announcement. They breached the door and announced as they entered the door. Sadly, that was not enough. The startled man friend of Breonna Taylor did what many of us would do during a midnight intrusion. He grabbed his pistol to protect himself and his woman friend. He fired his weapon at intruders rushing through the door. The officers killed Miss Taylor in response. The second problem is the need to serve a search warrant after midnight. Again, one must have exigent circumstances to request and act upon a search warrant during a time when most people are sleeping. If I remember correctly, in Philadelphia, we were prohibited from executing search warrants after 11 p.m. and before 6 a.m. unless we had a very good reason for acting within those times. I have yet to see information detailing the need to execute a warrant at Miss Taylor's apartment during a time when most people were sleeping. It is important to add that the target of the investigation that led to the death of Miss Taylor had already been arrested at another property. But the important issue here is freedom from unreasonable searches. I suggest to you that a warrant served after midnight, excuse me, in a no-knock manner was and is an unreasonable search in this incident. The incident that led to the death of Ms. Taylor was a systemic issue that involved the judicial system, prosecutors, police supervisors, and the executing police officers. No-knock warrants are useful law enforcement tools when monitored carefully and used wisely. Once unscrupulousness permeates not only the police department, but also its ancillary agencies, chaos reigns. People are unlawfully arrested, citizens' rights are violated, and sometimes people get killed. The solution is not to get rid of no-knock warrants, but to demand integrity and accountability in their use. This requires not totally blaming police officers, but also to look at the people who approve and sign these warrants. Judges or magistrates should not be immune from liability in such cases. Some acquiesce to police requests regardless of ethical or legal considerations. Just as Pontius Pilate, they figuratively washed their hands of the matter after signing the warrant. They must be held accountable. A recent article by investigative reporters for the Louisville Courier-Journal newspaper stated the following, quote, "Police disproportionately targeted black residents for no-knock search warrants like the one that led officers to Breonna Taylor's door. The common factors are the poor and people of color," end quote. Coupled with my personal experiences, I am sure this is pervasive in other municipalities. The public must take an active role in curtailing such incidents. Some of the solutions are mentioned in my autobiography. Here are a few suggestions. Regular monthly meetings between the community and their local police department must occur. The commanding officer of that district or precinct must attend along with a ranking representative of the Internal Affairs Bureau, just in case there are police complaints. Suspense dates must accompany each complaint received from citizens. Quote, "We are continuing our investigation," end quote, is an invalid excuse after 30 days. Definitive action resolving the issue must be accomplished and reported to the citizens of that community. Community members must be active in reporting suspected criminal activity in an anonymous way directly to their local department and their political leaders. Minority communities, because of mistrust of the system and fear of retaliation, are reluctant to notify police departments of illegal activity, even when that activity leads to loss of life. This has to stop. Police officers working in undercover units, such as narcotics or burglary details, should be limited to no more than 2 years in such assignments. Most scandalous behaviors in these units is usually committed by officers who have been in those assignments for several years. All no-knock warrants must be served with an assistant district attorney present. Their issuance should be rare. Each of these warrants must be served with an emergency medical team present until the property has been secured and cleared. All warrants that demonstrate a need to be served after midnight and before dawn must be approved by a police captain or above. A uniformed lieutenant or above must be present when these warrants are served. Again, these should be rare. These are just a few implementations that can preserve the integrity of warrants and contribute to the safety of police officers and citizens. Your thoughts and opinions can be shared with me via my website, www.bluewalkbook.com. Your actual email address is never sent to me, although I can respond to you. This protects us all. I thank you for taking the time to listen to this installment of Justice and Fairness in Policing. I am Norman A. Carter, Jr. Have a good day. Be an ambassador for good. Thank you.